Everyone. Got it. Okay, have a day and good morning, everyone. Today we have Kathlyn Selleck, who serves as our Chapter 7 and Subchapter 5 trustee for both Guam and the Northern Mariana Islands. And she's been working with us for a few years now. And prior to moving here, she served as Director of Medical Economics and Analytics for Aetna International in Seoul, South Korea. She received her bachelor's degree in accounting and finance at UC Berkeley and Haas Business School, and she received her certification of leadership and management with distinction from UC Berkeley Extension. We also we'd like to say a warm aloha to Elizabeth Kane, who serves as a panel Chapter 7 trustee in Honolulu, Hawaii. So welcome, Elizabeth, and thank you for assisting Kathlyn and working with our bar today. We appreciate it. Kathlyn is a solo practitioner with her own law office of Elizabeth Kane since 2023. Graduate of UC Berkeley School of Law, a member of the American Bankruptcy Institute, the Hawaii State Bar Association, the National Association of Bankruptcy Trustees, and the Hawaii Bankruptcy Bar Association. And she's a frequent speaker on bankruptcy topics at seminars. So we're going to let them go ahead and begin on Chapter 7 bankruptcy training here. So you guys may proceed, and Sazuz Masi and Mahalo.
All right. Well, thank you. Kathlyn, anything you'd like to say before I try to get the slides to work?
No, but I appreciate the opportunity to participate today.
Yeah, thank you. Same here. Oops. And the first thing that happened is my screen won't advance. All right. Okay. We're going to the agenda for the day. We're going to talk a little bit about the Chapter 7 process, and I'll be talking about that. Kathlyn will talk about trustees' duties, the 341 meeting process, trustees' avoidance powers. I'll talk about those two, and then Guam local rules and forms. Kathlyn will do it, and we'll share the chores for the tips. So moving right into this. An overview of the Chapter 7 process. There's really only a few steps, and the first is the debtor files a petition and the related documents, then and pays the filing fee. Some things happen immediately upon the filing of the petition. There's an automatic stay that's created, and a estate is created, a trustee is appointed, and then a notice is generated about the beginning of the case. I'll talk about at least some of those things a bit more. Then the next thing that happens from the debtor's perspective is there is a first meeting of creditors that's within 20 and 40 days after the petition is filed. 60 days after that, if all goes well, the debtor gets a discharge. At some point in the process, starting almost as soon as the case is filed and going until everything is finished, the trustee's job includes liquidating all of the assets and distributing to creditors. And you notice the slide says more than 95% of cases are no asset cases. And that means there's nothing to liquidate, nothing to distribute. The case is closed, and the majority of cases are closed very quickly, no more than 4 months after the beginning of it. As the previous slide said, when a bankruptcy is filed and a estate is created, and that estate includes all of the legal and equitable interest in any property that the debtor has as of the commencement of the case. This would include legal claims that the debtor has against others. So if the debtor has been injured in a car accident and is thinking about suing the other driver, that claim belongs to the trustee. A couple of other things that are property of the estate that aren't automatically or aren't necessarily obvious. By statute, if a debtor receives property by inheritance within 180 days, that's 6 months after the bankruptcy is filed, that becomes property of the bankruptcy estate. Also, sometimes the trustee is able to recover property that the debtor transferred away up to several years before the bankruptcy was filed. That becomes property of the estate as well. But what is not property of the estate? It's property in which the debtor holds only legal title but no equitable interest. That would be a case where the debtor is serving as a trustee for somebody else who's a beneficiary of an estate or of a trust. If the debtor has a beneficial interest in a spendthrift trust where somebody else set up a trust where the debtor is a beneficiary, but the debtor cannot themselves control the money, then that doesn't come into the bankruptcy estate. Some retirement accounts, education savings accounts are not property of the estate. And in a Chapter 7 case, income from personal services, that's the work that the debtor does in their job after they file bankruptcy, that doesn't become property of the estate. But as you can see, the property of the estate is still very broad. Everything the debtor owns, has a right to, or even thinks they may have a right to, as the date of the bankruptcy petition, becomes property of the estate. And who controls the estate? That is to say, me and Kathlyn, the trustee by law, is the person who's responsible for all of that property. The debtor, by signing and filing that petition, the debtor has essentially signed away everything they own, and the trustee is the one who's responsible for liquidating and managing or disposing of or giving back to the debtor, as the case may be, property, everything that the debtor owns. The case trustee, that is to say, Kathlyn and myself, are different than the United States trustee. The United States trustee is an employee of the United States Department of Justice, and that office oversees all of the activities of the private case trustees, serves as a watchdog for debtor misconduct in all cases, or all kinds of cases, not just Chapter 7 cases. It's a different animal altogether from those of us whose job it is to deal with individual debtors and individual cases and liquidate the property from individual debtors. One thing I want to say right now before I forget about it, I would like this to be as informal as possible. So if any of you have questions, please feel free to raise your hand, interrupt me if necessary, and I will try to answer your question before I go on to the next thing. How does property leave the estate? Since everything comes in the instant that somebody files bankruptcy, a bunch of different ways. Easiest, trustee sells it, court approves the sale, sign over the deed to the house to somebody else now owns it. Other way is if a debtor claims a property or an asset as fully exempt, and Kathlyn will talk about that when we talk about, she talks about exemptions under the Guam statute. For example, in Guam, if they have a homestead, they claim the homestead exemption, as I understand the Guam rules, and I may be wrong, that if within the 30 days after the first meeting of creditors ends, if nobody objects to that exemption, claiming that homestead property, that property reverts to the debtor. Another way is by abandonment, and that's a technical bankruptcy term, meaning it leaves the bankruptcy estate. If property is abandoned by the trustee, it goes back to the debtor. Abandonment happens either by notice in the hearing, when the trustee says this property is cumbersome, I don't want to bother to administer it, and it reverts back to the debtor after the court approves that. If property is listed in the debtor schedules and the trustee decides not to administer that property, the debtor owns it free of the bankruptcy estate after the bankruptcy is closed. If the debtor fails to list property, fails to disclose it, and the trustee can't administer it during the regular course, if the trustee ever finds such property, even long after that case is closed, the bankruptcy is reopened and that property is still available to be administered for creditors. I mentioned earlier in the overview, the automatic stay is one of those things that happens the instant a bankruptcy is filed. That is a form of statutory injunction under federal law, and that stay stops all litigation, all collection activities against the debtor by anybody. And that's a very valuable reason why someone would have to file bankruptcy, is that all collection calls, the harassment that they get from creditors has to stop. Here's a little of what the statute says. The number of things that are covered, as it says, operates as a stay applicable to all entities of the commencement or continuation, including the issuance or employment of process of a judicial, administrative, or other action or proceeding against the debtor. That means if somebody has sued the debtor, that lawsuit stops in its tracks the minute that the bankruptcy is filed. The enforcement of a judgment that was obtained before the petition was filed, that is also covered by the automatic stay. Any act to obtain possession of any property of the estate or from a property of the debtor either. And the list goes on. That's in Bankruptcy Code section 362. I commend that to you for the full list of what is covered by the automatic stay and what are the exceptions to the automatic stay. What if the debtor is a plaintiff in a lawsuit? Since the earlier screen said that all lawsuits against the debtor stop. Well, the stay only affects the claims against the debtor. If the debtor is the person who is suing somebody else, the automatic stay doesn't prevent the trustee from continuing with that lawsuit to collect money against whoever owes money to the debtor. If there has been a receiver or a commissioner appointed, say in a foreclosure or some other kind of action before the bankruptcy is filed, the receiver or the commissioner must turn that property over to the trustee. And if the receiver thinks that there is some reason why they are best to continue managing this property, they can ask the bankruptcy court for permission for them to continue managing the property. In my experience as a Chapter 11 trustee, as well as a Chapter 7 trustee, receivers and commissioners are generally happy to turn over the headache of collecting rents from a small strip mall over to the trustee. They don't want to be, they are not compensated nearly well enough to deal with the hassle for that. And if there's a bankruptcy and somebody else can take the job over, they're happy to let it happen. That's in my experience. Your mileage may vary. Okay, Kathlyn, your turn. You're muted.
All righty. Liz, do you want to let me share my screen? Oh, you're now muted. Okay, let me see if I can share my screen. And we'll talk about the trustees' duties. Okay. Can everyone see that?
Yes.
Thank you. Okay. So the trustees' duties are covered under section 704. And let's see if I can get my slides to move. Hold on. All right. So in section 704A1, it says the trustee shall collect and reduce to money the property of the estate and close the estate as expeditiously as possible. And essentially, again, the duty is to identify assets, and if there are sufficient non-exempt equity, the trustee will sell the assets to pay the creditors. So any assets that are non-exempt will stay with the debtor. And exemptions actually only apply to individual debtors. So if it's a business, we would not apply exemptions. Under 704A2, it mentions that the trustee is accountable for all property of the estate. So if it's determined that there are sufficient non-exempt assets, the trustee is responsible for ensuring that the assets are safeguarded. So if it's a business, we would put locks on the doors, for example. We would need to make sure there's adequate insurance. And so we have to make reports and keep account of any and all assets that come into the estate. Okay. And we'll talk a little bit more about the 341 meeting, but the trustee is also responsible for investigating the financial affairs of the debtor. So we will look at the filed petition, the schedules and the statements. And if necessary, we will look at, say, bank statements. So we may ask, in addition to the tax returns, the trustee may ask for bank statements or loan statements. We look at property deeds. We may look at the tax rolls just to see if there's property under the debtor's name. And we want to make sure that the information that's on the petition and schedules is accurate and complete. So, for example, again, if there's a loan for a mortgage, I would ask for a loan statement to make sure that the value of the loan is consistent with what's recorded on the petition or the schedules. Okay. Now, are there any questions, about investigating the financial affairs? If the debtor is not behaving appropriately, then the discharge can be opposed. And inappropriate behavior could be knowingly hiding assets or making a false oath, or attempting to hinder or delay the administration of the case. So the trustee can, under certain circumstances, oppose the debtor's discharge. And if there is an asset case, if there's sufficient non-exempt assets available to distribute to creditors, then once the assets have been identified, we will notify the clerk of the court to ask creditors to file a proof of claim. And once the asset has been sold, I will prepare what's called a TFR, or trustee's final report. And that report will list what will be paid out to the creditors. So what will pay to to DRT, what may be paid to the IRS. If there are secured creditors that need to be paid, we would outline what the secured creditors would be paid. And then for unsecured creditors, we pay what's called dividends. And that report goes to the U.S. Trustees office for review. If they are okay with it, then we will submit it to the court for the judge's order. And once the judge's order comes in, we will make what's called a final distribution, which is just payment. We'll write the checks out to the creditors. And then within 125 days after the order, we'll submit to the U.S. trustee what's called a TDR, and it's a final distribution report. And that'll just list, everything that was actually paid, and I'll submit, the bank statements that show zero balance. And I'll just certify that the estate has been fully administered. So any questions or comments on the trustee's duties? Okay. All right, so Liz, you're up.
Oops. Can you see if you can give me authority to change those screens? Oh, no, mind, I will just share mine. Oops, it's still not letting me share. Okay. Bear with us, folks. There are always some little technical glitches of these things. Okay. Can everybody see my screen?
Yes.
Okay, thanks. All right, now I'm going to talk about the first meeting of creditors, which is one of the things that happens in every bankruptcy case. As I said earlier, in a Chapter 7 case, that happens between 20 and 40 days of when the petition is filed. That's under the statute. It's also called, first meeting of creditors is also called a 341 meeting. That's because Bankruptcy Code Section 341 is what provides for it. Every Chapter 7 debtor is required to appear and be examined under oath. What the trustee does, and that is to confirm the debtor's identity. I have a dozen standard questions that I have to ask, and then other questions specifically related to that. Creditors get the chance to ask questions for it. This has the site. Section 341 provides for the meeting. 341(3) says the debtor has to show up, and 348 says if a case was converted from another chapter to Chapter 7, we have to start that process over again and have a new first meeting of creditors. What we need for debtors to do before the first meeting of creditors: provide a trustee with a copy of the most recent federal income tax return. And that does not necessarily mean the most recent tax year. If the debtor didn't file taxes yet for 2023, for example, I want to see the 2022 tax return. If the debtor didn't file taxes in 2022, I ask for the 2021 tax return. If it's more than 3 or 4 years old, it usually isn't going to be very important, so I don't ask for, and the debtor isn't expected to provide a really old tax return. But they need the most recent tax return that they filed, whenever that was. Be prepared to provide it to the trustee. Also, to provide a trustee with copy of their pay stubs if they're employed for the 60 days prior to the bankruptcy. If they're not providing the tax return or pay stubs, there is a form, and Kathlyn will show it to you later, I think, explaining that the debtor has to send to the trustee, explaining why they're not giving them. Another thing that is required is that I have to know and confirm the debtor's identity. So the debtor has to send me, or the trustee, a copy of a government issued picture ID and a copy of their social security card or some other document that provides proof of their social security number. Those documents have to be something that the debtor didn't create. So if we have a debtor's tax return, doesn't prove the debtor's social security number because the debtor typed that into something. Social security card, Form W-2, 1099. Some people send me social security statements. Things like that are good. Some employers used to put the full social security number on regular pay stubs. I don't think anybody does that anymore, but if the employer's pay stub to the debtor has the debtor's full social security number on it, that could work as well. The documents have to get to the trustee. The rule says 7 days before the meeting, but I think both Kathlyn and I can give people a little bit of leeway if they're late with that. You can mail them by postal mail. If you've got a secure email system, you can do that, or you can upload it electronically through a secured system. And Kathlyn has something set up from Axos to do that. Here in Hawaii, the court has a secure portal to upload documents to trustees. If those documents don't get to the trustee well in advance of the 341 meeting, it's not good. Either the meeting at the minimum gets continued, because if I can't look at the debtor's face on a picture ID and compare it with the face that I see on Zoom, I can't ask debtors any questions. If I haven't seen the debtor's social security card, I can't ask any questions. The meeting gets continued. And if the debtor is really just deciding that they don't want to prove who they are, that's because that's one of the things of the duties that it's of the debtor that's required. It can be cause to dismiss a case. Things that we need debtors' attorneys to do. And this is, all of these things are pet peeves, are important for trustees, at least in my perspective. Review and be familiar with the statements and schedules. Go over them with the debtor and catch if there's any mistakes, because of one of the standard questions are there any errors or omissions to bring to my attention at this time? So go over them, make sure that they're accurate, be familiar with them. Both the debtors and the attorney should do that. The debtor needs to be able to, if there is a domestic support obligation, that's a alimony, child support, something else ordered by the court in that nature, they need to be able to provide the trustee information about how to contact that person, because the trustee has an obligation to send to somebody who is owed a domestic support obligation a form letter, and that letter has to go out pretty quickly after the first meeting of creditors. So it's important that the information be at hand and available for the debtors to give to the trustee. Debtors need to know where they work. The next thing, need to have the address of their employer. The number of times when I ask, please tell me the name and address of your current employer, they will say, well, it's someplace on the military base over on the west side of the island. Sorry, that isn't any good. I say, look at your Schedule I and your bankruptcy paperwork, and it will list the address of your employer. Can you please read that and tell me out loud, and then tell me if that's where you work? But they should know that. You should do it ahead of time. Next thing relates to that, have a copy of the statements and schedules, because sometimes I will have questions specifically saying, on your Schedule I for your income, you said your total take-home pay is $1,000 a month, but I see your tax return that you just filed for this past year shows a very different number. Can you explain what's going on with that? So have the statements and schedules there so I can ask a question about them if necessary. And if you need an interpreter, or the debtor needs an interpreter, please let me know, or Kathlyn know in advance, so we can all be prepared for that. On the day of the meeting, be on time. It's going to be on Zoom. The notice of the court from the court will give you the Zoom login. It's important that the camera and microphone should be working. I've had debtors who have called into the 341 meeting on their phones, their smartphones, and I say, I need to see your face. And they say, oh, well, I don't know how to turn it on. Turn on the camera. Please know how to turn on your camera and have it working. That is for debtors and debtors counsel. I need to be able to see the debtor at least for long enough to confirm that the face of the debtor on the driver's license is the same as the face of the person I see on Zoom. And I can't do that if they're not on camera. And also need to confirm that the when I'm putting the debtor under oath, that the debtor is raising their right hand. Little things like that. It's important that the camera be working and the microphone be working. Another thing that's actually required under the rules now is that nobody be with the debtors other than the debtors' lawyers at the time they're doing the 341 meeting, because we can't see the overall picture of who is not on camera. It's important for the integrity of the process that the debtor not be coached, that somebody isn't there helping them, providing them with information. We need to have the debtors' best answers to the questions. They are under oath. It is a very serious proceeding, even though sometimes we treat it informally. It's important that the debtors be there with their lawyers and not somebody else. Okay, what to expect? Sometimes there are, at least in Hawaii, we have 3 cases that are always scheduled at the same time frame. I don't think in Guam we're quite so compact, but if there's multiple cases scheduled for the same time, check the calendar to find out when your case falls in that time frame. Trustee's going to call the cases in the order that they are on the court calendar. Before I start the meeting, they may chat a little bit with debtors' counsel to indicate that something's missing, let them know what's going to happen. It's not at all uncommon where counsel and I will have a brief chat. I will tell counsel, I didn't get a tax return from you. We're going to have to continue this. The continued date is going to be such and such. And I'll let them know that ahead of time before we get started on the record. The meetings are recorded. We start them officially by, I'll push the record button on the recorder and I will say calling case 24-0001, debtor's name. And then next we'll say, counsel, enter your appearance, please. And the debtor's attorney will enter their name. And then I will say, for the record, I've reviewed the copy of the Hawaii driver's license in my case, and social security card provided for this debtor. The likeness of the debtor on the driver's license matches the face of the person that I see on Zoom. The name and number on those documents match that in the bankruptcy paperwork. You can tell I've got this, I do this so often, it's memorized, it's rote. It doesn't even go through the brain as I'm saying all of that. The form of identification is therefore acceptable and we're able to proceed with the meeting. At that point, I ask the debtor to raise their right hand and I say, do you solemnly swear, and I do myself too, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? And then I launch into my dozen standard questions. Notice the first things to know during the meeting, relax, breathe. This is not scary, or it shouldn't be scary. Just the debtor should know ahead of time what those dozen standard questions are. And I'm not going to take the time now to rattle them off, but it takes roughly 3 minutes to go through those same questions every time. And the trustees are required to ask those same questions every time. Then I'll ask other questions that are related to the case and that particular debtor. I'm going to focus, and I think so does Kathlyn, on 2 other main areas. One of them is if I've noticed something is inconsistent in the various sections of bankruptcy documents, like, for example, the debtor says, I have not had any previous addresses, not lived any place else other than where I am now in the 3 years before the bankruptcy petition, but the tax return has a different address than the ones they've listed. So that's a question. How did that happen? Or the tax return will show a mortgage interest deduction. The debtors will say, the debtor schedules will say they don't own any real property, never owned any real property. Inconsistencies, things that don't add up. One little tiny thing I used to do, I haven't done it lately because it does not seem worth asking about, but I've noticed debtors used to often list pet expenses, $100 to $150 a month that they were paying for pet food. And then I would check to see if the debtors owned a pet. And if they didn't, I say, why didn't you tell us you owned a pet if you're paying for pet food every month? On that rare occasion that they own some fancy purebred animal that's worth hundreds of thousands of dollars, I don't know what animals are worth, then it would matter. But for the most part, now I quit asking if the debtors have a pet when I see pet food as an expense, but inconsistencies like that are things I look for. And then the other main area is to ask about assets and liabilities and collect documents. I want deeds, I want mortgage statements, car loan statements. If they've said they have a car and there's a car loan of almost as everything that the car is worth, I want to confirm that that's the case before I proceed with that. Those are the main areas that I ask questions about. Okay, I'll ask for documents. Then after that, I ask if there are any creditors or others who wish to examine the debtor. And any creditor can ask questions of the meeting, of the debtor at the meeting. And at the end of the questioning, the trustee, I'll either close the meeting or continue it. Those are basically the two choices. And one of my favorite things is for a case that is very simple and straightforward from my perspective, when I'm able to say to a debtor that this meeting is concluded and this debtor is excused, the look of relief that comes over those people's faces to know that they have passed what is one of the more significant hurdles in their bankruptcy case. Maybe the only time they will see somebody, and it'll be the only time that they answer questions under oath out loud. To know that they've gotten through that makes people very happy and relieved. And I love to watch people be happy and relieved at the end of the 341 meeting. Okay. Comments not going. The next big area that I'm talking about is avoiding powers. That means the ability of a trustee to avoid or undo transfers of property that were made before the bankruptcy was filed, or in one case after the bankruptcy was filed. Those are found in sections 548, 544, 547, 549 of the Bankruptcy Code. Avoidance is not the same as recovery. If once a trustee avoids a transfer, sometimes I need to actually do something to get the property back. In the case, let's say a debtor made a payment to a creditor shortly before the bankruptcy was filed, way outside of the ordinary course. I can, the first step is to avoid that transfer, say it is undone, and then the next step is to tell the creditor, pay me the money back. That is recovery. And in general, unless we're able to work out something to avoid a transfer and recover it, requires actual litigation, a complaint, and summons and everything else that happens. We call those adversary proceedings in the bankruptcy world. Bankruptcy Code section 544 is when a trustee uses this to avoid a security interest that wasn't properly perfected before the petition was filed. Say, for example, the debtor borrowed money from a credit union to buy a car, and the credit union didn't get around to recording or filing the title, getting its name on the title, or getting a title issued in its name. The credit union may not have a lien on that car as a result of that. If somebody planned to sell real property, didn't get around to recording the deed out of the estate before the bankruptcy was filed, that transfer can be avoided. In those cases, nothing needs to be recovered. I'm just avoiding a lien that was not properly perfected, or in this case, avoiding a transfer of real property that wasn't finished. And the second thing with real property, this happens more often than you would imagine in divorce cases, where a divorce settlement says, spouse A is awarded the marital residence all to themselves. And it will say, and spouse B must sign over the deed. Well, spouse B doesn't sign over the deed. Spouse B files bankruptcy, and it falls to the trustee, unfortunately, the duty of going back to spouse A and saying, you know, that house you thought you owned? Sorry, it isn't all yours, because you didn't get the deed recorded before that your ex-spouse filed bankruptcy. People get very angry about that, and it's understandable. They may have some claim back against the debtor, but for the estate and the creditors, it's my job to collect that property and to sell it for the benefit of the creditors. Under also Section 544B gives a trustee the power to use state law. In this case, it would be Guam law, which has, I believe, a variation on the Uniform Fraudulent Transfer Act to avoid transfers under state law. Section 547, I mentioned what happens if a debtor makes a large payment to a creditor just before the bankruptcy is filed. This is what is generally called in the bankruptcy system a preference. The creditor has preferred one creditor over another. It applies for payments that are made within 90 days before a petition, or up to a year if it's an insider that got the money. Payment was made on account of an antecedent debt. That means a debt that the debtor owed before they made the payment, an old debt. Allowed the creditor to receive more than it would have under a Chapter 7 liquidation, and the debtor was insolvent at the time. If those four conditions are met, then the creditor will have to give the money back to the estate. There's a couple of exceptions. One of them is if the exchange was roughly contemporaneous, and after the debtor made the large payment, the creditor went ahead and issued new credit back to the debtor so that the debtor borrowed more money. The trustee can't recover anything in that circumstance other than the difference between what was paid and the new value that was given. And then in the other circumstances, if it was within the ordinary course of business of the debtor and the payee, if the debtor has been paying off their credit card bill every month all along, and they paid off their credit card bill the last time they used it within 90 days of the bankruptcy, that's in the ordinary course of their financial affairs. I wouldn't be able to recover that payment either. Section 548, sometimes called a fraudulent transfer, and there's two main kinds. One of them is transfers made with the actual intent to hinder, delay, or defraud creditors. And the other is, we call them constructively fraudulent transfers. And those were transfers that were made for less than reasonably equivalent value. And it's a whole lot easier to prove just that somebody gave something to somebody or sold something to somebody for less money than something is worth than it would be to prove that they made the transfer actually trying to hinder or delay or defraud creditors. So if, for example, somebody decides to give their house to their son in exchange for the son promising to take care of the mother forever, or whomever, the debtor, that promise to take care isn't worth any money. So the gift of the house was made for less than the value, reasonably equivalent value, and the trustee can avoid that transfer, can ask for the house back, can sell it, can use the money to pay creditors. You can't avoid paying your creditors by giving your property to your kids or your parents or your cousin or anybody else you want to. You can't do it by making a sweetheart deal, by selling the property to somebody for far less than it's worth. Just saying, I want it out of my hands. I don't want to deal with it anymore. The trustee can recover that property for the benefit of creditors. 549 has to do with transfers that are made after the bankruptcy was filed without getting permission from the bankruptcy court first. It happens on occasion that a debtor is in the process of selling a house and the deed doesn't get recorded until after the bankruptcy was filed. Depending on whether the buyer either had notice of the bankruptcy and paid full value of it for it, the trustee may be able to get that property back as well. Oh, and now we're up to Kathlyn's turn. Before I move on, any questions?
Well, Liz, I will say that you're able to do your 341s in 3 minutes, and it takes me a little longer, so probably more like 10 on a good day. But let me go ahead and share my screen. Let's see. Okay, so I'm going to talk a little bit about some of the local rules and forms, and primarily the forms. Again, let me see if I can get my screen to move. Okay, so in Guam, we have what are called bankruptcy local rules, and they're referred to as BKLR. And in the local rules, you'll have what are forms that we use in Guam specifically. Now, actually, all of the forms are available online, and if you'd like, I believe you can just go to this link that I have here, and you can download them all. One of the forms that is used when you're filing the petition in Guam is Form 5005, and it's a electronic filing form. And here you would enter the debtor's information, the case number, the chapter, and then just indicate what all is included in the filing. So this is one of the forms that I've seen used locally in Guam. I'm not sure if they use this type in Hawaii, but if you're filing a local case, you would want to use this form. And as Liz mentioned, for the 341 meeting preparation, we'll need tax returns. The two most recent are what I request. And again, if they haven't filed in the most recent year, it doesn't have to be, say 2023, but I will ask for the most recent tax return filed. Also pay advices or information on income. So if they're actually receiving Social Security, I'll ask for that statement. We'll need a photo ID or identification, such as a passport. And then we'll request a Social Security card or some version of, or some information that can confirm the Social Security number. And again, if there's a domestic support obligation, we'll want the payee name and address to be made available either before the meeting or immediately after. Now, this is a form that is used to submit the information that I was just talking about. So this information, the pay advices, the tax returns, the DSO information, this information is not filed with the court, but submitted with the debtor's information. And if you have a secure email, we can use that, or I have what's called a Access document delivery system, and counsel can upload these documents to a secure location. And so you'll notice here, if the debtor is not submitting a tax return for some reason, they don't have sufficient income, then you would just indicate that on this particular form. Another form that's used, it's GUB 1009. And we would, this form is actually filed with amendments. So if after the 341 meeting, there needs to be some amendments to, the asset schedule, or if you need to change or update the exemptions for the debtor, or, add to your list of creditors, this form is used to indicate what changes were made or what amendments were made. And Liz, is this form similar to something in Hawaii, or is it a little bit different? Oh, you're on mute. Sorry.
Just looking for the unmute button. Yes, we have a very similar form in Hawaii.
Okay. All right. Now, Guam debtors can select either the local exemptions or the federal exemptions. And these exemptions are on Schedule C, and there's a checkbox. So if you're going to select the local Guam exemptions, the property exempt is listed under 7 GCA 23111. And in Guam, for example, if you declare a homestead, that can be exempt if you select the Guam local exemptions. And Code 43101 also defines what is a debtor's homestead. So generally, what I would look for if a debtor is going to select the local exemptions is a filing with the Department of Land Management declaring the debtor's homestead. The federal exemptions for the other assets tend to be, I believe, more generous. But if the main asset is a homestead, then counsel and debtor may consider selecting local exemptions. Okay. Are there any questions? I know that we're moving kind of fast here, but any questions on anything related to Guam's local exemptions or rules? Or if anyone from Guam would like to speak about the local rules, please feel free, Francine. One other quick exception that Guam has is when I file what's called the final report, the TFR, there's a 30-day period to appeal or to object to that TFR, as opposed to a 14-day if there's a bankruptcy court. And Guam is a district court, and I believe it's not a bankruptcy court. But Curtis, if you wanted to talk about that a little bit, that please jump in. Okay.
Well, the Guam exemptions are exactly as you said. They can choose Guam exemptions. They can choose the federal bankruptcy exemptions found in 522D. They are different. Most debtors on Guam and Saipan choose the federal bankruptcy exemptions on 522D. They're a little bit more up to date. They're a little bit more generous in most respects. So most people choose 522D exemptions, and they allow a good amount. Most debtors are able to exempt everything they own through those exemptions, so that there's nothing left for a trustee to administer, which is why the vast majority of cases are cases that do not involve assets recovered by the trustee.
Curtis, can you mention about the time to reply to the TFR. So I think that the bankruptcy court will allow, it's a 14-day period after the TFR order is.
You know,
is
it's, so there's a note, the notice of final report goes out that gives parties, I think it is 14 days to raise an objection to the final report. We rarely get objections to trustees' final reports, but it is possible. It happens once in a while. I mean, you had one in the Polaris case. But yeah, the vast majority of the time, there's no objection. But in theory, creditors will get notice of the final report or the notice of final report. It shows what the proposed distributions are. And then creditors can raise an objection if they feel that something is wrong in there, that the fees are too high, the amount that they are being paid is not the correct amount for some reason. They can raise an objection, and if an objection is raised, then a hearing will be set before the judge, and the judge can then rule. You know, the trustee can respond to the objection, and then the judge will make a ruling.
Now, the time period, though, is 30 days in Guam as opposed to 14.
Okay.
Is that,
Are you talking about an appeal or an objection?
All right.
No.
Can I jump in, Kathlyn,
Yes.
do you mind, Curtis? Kathlyn and I talked about this the other day. The order approving final report that comes in Hawaii says trustee must begin making distributions no earlier than 14 days after the entry of this order and no later than 30 days after the entry of this order. The Guam order says trustee shall commence making distributions no earlier than 30 days after the entry of this order. And Kathlyn and I think that the reason for that is the the time when someone can appeal from the entry of an order is 14 days if the bankruptcy court enters the order and 30 days if the district court enters the order. And I think that's what Kathlyn was asking. I'm sorry, Kathlyn,
sorry.
if I stepped on your toes and trying to interpret.
Yes, so yeah, that's absolutely correct. That's the reason for the two different time periods, because in Hawaii you're dealing with the Hawaii, the federal bankruptcy rules, which provides a 14-day appeal period, and then in Guam and in Saipan you're dealing with a district court that's sitting in bankruptcy, but the district court, of course, has a 30-day appeal period. So that's absolutely right.
You're right.
thank you.
Can you hear me?
Yes.
Hi, it's Francine. Yeah, appeals from a bankruptcy court are taken directly to the Ninth Circuit in our district for Guam.
Oh,
Whereas before, I think in other bankruptcy courts, it goes from bankruptcy to district and then to the Ninth Circuit. Is that right? Is that correct, Curtis?
Yes, that is correct.
Okay. And Kathlyn, with regard to the Guam local forms, and Guam local rules, we did, when they were initially adopted, we did mimic and borrow a lot of our forms from Hawaii. So if Ms. Kane, if you saw a lot of similarities, that is the reason.
Okay. Okay. Well, that's all I have on the local rules and forms. So next we wanted to talk about tips. And Liz, I'll just go ahead and keep control of the PowerPoint.
that's great. Thank you.
But why don't you go ahead and just.
All right. Well, I've touched on some of these things before. What I expect, what Kathlyn expects, what most trustees expect is that the bankruptcy schedules are accurate, they're consistent, they're complete. If people make mistakes, that's okay. They'll get a chance to fix them. But it really will rankle me if the debtor's attorney didn't notice, for example, that the debtor says that the debtor has never lived in any place other than where they live now, and the address on their driver's license is different, or the address on their tax return is different than in their bankruptcy paperwork. Somebody should have asked those questions ahead of time to catch those little inconsistencies that perhaps don't mean anything, but it slows everything down if people don't check to make sure things are correct. I expect the debtor's name on their driver's license to match the debtor's name in the bankruptcy petition. The number of times where somebody said, well, I never use my middle name, so why should I have to put it on my bankruptcy petition? And I say, if you can't fly on an airplane with that name, you can't file bankruptcy with that name. You have to have your full legal name. If you've been known by any other names, please list that. I expect accuracy, consistency, and complete. The other thing that I expect, that any other trustee, I think, expects the same thing, because the law requires it, is that the debtors cooperate and communicate with the trustee. Please don't drag your feet. If I say, please get me a copy of your most recent mortgage statement, don't say, I don't know what I did with it. Say, yes, ma'am. When do you need it? So that's what I expect from debtors. From creditors, the main thing is, if we're going to file a proof of claim, support that proof of claim. Show me that you're really owed the money. Don't just make up something. Those are the main things that I expect: honesty, accuracy, completeness, consistency, cooperation. Oh, it's interesting. I've now hit all kinds of C words for this, for alliteration. Kathlyn, you want to do the next
Well,
slide?
I think, yes, and I just agree. Fortunately, we've been very fortunate to have very cooperative debtors and counsel here in Guam. And we just want to reiterate it as well.
Okay.
Okay. So next we have tips for the debtors counsel. So if you are representing a debtor, it's helpful if you've gone over the statements and schedules with the debtor and just make sure that everything makes sense. There are standard questions that we ask at every meeting. So again, it's helpful if those questions have been reviewed with the debtors. And if necessary, if we need additional documents like deeds or mortgage statements, or if we need something that helps determine the value of, say, a car for sale, that we have, would you go ahead and have that blue book page ready? Oops, sorry. Do you want to say more about the creditors counsel, Liz?
Oh, yeah. Well, the creditors counsel, I expect, if creditors have reason to suspect that the debtors have not been honest with me, you see something that's wrong, let me know. The number of times that I have discovered that debtors have not listed some property, I've discovered it because a disgruntled former spouse or a creditor that got a financial statement from the debtor not that long before the bankruptcy, they will alert me that things are not consistent. The former spouse will say, I know I gave that person, I had it happen, a Porsche in the divorce, a $90,000 Porsche. Did she list it? Oh, did that debtor? No, that debtor didn't list it. Well, I sold that Porsche because I found out about it from the former spouse. Those things happen. And creditors, if you see something, let me know, because it's my job to track down and sell that property if it's really real. But the other thing is, not so much in Guam, but in Hawaii, there are a lot of different meetings scheduled for the same time frame. We don't have all day to do this. We can take a long time if needed, but when creditors are asking questions, don't use the time to ask questions about your claim against the debtor. don't use the time to harass the debtor saying, why did you borrow this money if you didn't intend to pay it back? Don't use the time to build up your case to argue that the debtor was dishonest on their loan application. That's not what this is for. The first meeting of creditors, you get some time as creditors counsel to ask questions, but the primary focus of the questions that you're to ask is to help the trustee decide whether there's property that needs to or can be administered, and the trustee decide whether there is something dishonest about the debtor that needs further investigation. And as Kathlyn mentioned earlier, potentially objecting to the debtor's discharge because of something that the debtor has done incorrectly. So those are the main things that I think of for creditors counsel. Do you have anything else, Kathlyn, that you like and expect for creditors counsel? Some tips?
I think mostly just being familiar with, being familiar with the schedules so that, they know if there is anything that looks amiss, to point it out. So the sooner we know, the better. So if there's bad news, report it as soon as you know it. But other than that, I think we've been very fortunate with our counsel here. That we've gotten a lot of cooperation and they've been very helpful. So
Okay. Well, we have a little more time. I think the next slide just says questions. First, are there any questions for either of us? And second, would you guys like me, since I didn't earlier go over the dozen questions, the dozen standard questions, would you guys like us to go through them, since we have a few more minutes? Nobody's saying yes.
Sure, that would be helpful. Thanks.
Okay. All righty. I'm gonna, even though I have them memorized, I have them written down on a big sheet of paper, so I won't forget them ever. Kathlyn, you can jump in. First, please state your full name and current address for the record. These are the standard questions. Did you sign the petition, schedule, statements, and related documents filed in the bankruptcy case? Is that signature your own? Did you read the petition, schedules, statements, and related documents before you signed them? Are you personally familiar with the information contained in the bankruptcy petition, schedules, statements, and related documents? To the best of your knowledge, is the information contained in the bankruptcy petition, schedules, statements, and related documents true and correct? Are there any errors or omissions to bring to my attention at this time? Are all of your assets identified on your schedules? Have you listed all of your creditors on your schedules? Have you previously filed bankruptcy? What is the name and address of your current employer? Is the copy of the tax return you provided a true copy of the most recent tax return you filed? Do you have a domestic support obligation? Have you read the bankruptcy information sheet? Those are the dozen questions that we are required by law to ask in every case. If you notice that some of the questions have subparts, so there's really 14 of them, but they're numbered 1 to 12. Kathlyn, I assume you have a cheat sheet pretty much like this and ask your questions. You probably have them memorized. I do too, but I always like to look at them when I'm reading, when I'm saying them.
Yes, I do have a sheet. Haven't quite memorized them yet, I don't think. So please don't ask me to state them, but.
Yeah, anyway, and as to where these questions can be found, there is something called the Handbook for Chapter 7 Trustees, and that lists all of the trustees' duties. I don't know how many pages long that document is, it's hundreds, but one of the addenda, I guess is the right word, or attachments to that handbook has the list of questions. As I said, we're required to ask them by law. The reasons for some of them can be are pretty obvious. You're giving the debtor a chance to say, to correct any errors right there on the spot. Any errors or omissions to bring to my attention at this time. You're asking the debtor to confirm that that's their signature. They read that document before they signed them. The failure to answer those questions honestly is a federal crime. And it's because it's perjury. They're answering under oath that they're personally familiar with these documents and now are the information in these documents. If it turns out, as sometimes debtors will say right after that, oh, well, I didn't read it. Somebody else filled in all this information. I don't know anything about that. I have to back up and say, wait a minute, you just earlier said you read this, you signed it, you're familiar with the information, it's all true and correct. And now you're saying you're not familiar with the information? Please explain that. So the reasons for this are very serious to ask these standard questions. And I recommend any debtor's attorneys make sure that their clients know what is expected of them. And one of the things that's expected of them is to be able to answer those questions under oath. And under oath, they've got to say, I'm familiar with this information. So, okay, off my soapbox. Anything else, anybody?
Yeah.
Curtis, I'll bet you have the handbook page memorized and can look up and tell us exactly where to find it.
Not at all.
Okay.
So are there any questions, comments, concerns? Okay.
I have
Karen,
I have
Oh.
no comments. Thank you. That was very informative.
Thank you, Judge.
hmm,
Thank you.
that's Francine. Thank you, Francine.
Yes, thank you so much both for your presentation, and Mr. Chang, thank you so much for chiming in as well. I know you weren't presenting. You will be next month, but thank you for chiming in. And thank you everyone for attending.
Thank you.
Thank you.
Thank you all. If there's nothing else, who officially closes this?
Chuck does.
Yeah, I'll reiterate. Thank you so much for helping us out in this. Our intent is to grow our bankruptcy bar here, our debtors bar here, which has been diminished a little bit. We want to do that in the right way, and we've recorded this session, and with the permission of the presenters, we'll put this presentation on our website for future CLE opportunities for interested attorneys. So thank you for your generosity.
Thank you
very
again for
much.
your time.
Thank you, and thank you for the
All right.
opportunity. Thank you.
Okay,
All right. Bye-bye.
bye.
Bye-bye.
Bye all.
Bye.